Hello, good afternoon, everyone. So I hope you guys are doing fine today. I see a couple of participants so far. So, guys, we'll give about 3 more minutes for people to join, and then we'll start. I hope that's fine with you guys. So, like, so basically, I think the delay in some of these cases are because we have heavy rainfall out here. Okay, and some of the people might actually not have proper network. But still, for the sake of starting the program, I'll just go ahead and start it. Okay, and then let people join over the period of time. We'll give another 2 to 3 more minutes, while we start this introduction. So today we have Ms. Neil Kamal Jain, founder of Neil Kamal and Associates, an advocate and IPR attorney, okay, with us. So she majorly deals with intellectual property rights. Okay, and today's session is all about it. So I'll quickly hand over the introduction to Neil Kamalji. Ma'am, are you? Can you hear me?
Yeah. Good afternoon, good evening, and everybody. Good evening, sir.
Good evening.
So, shall I start the session?
Oh yes, you can start with the introduction, and in the meanwhile, we'll give around 2 minutes for people to join.
Okay. Okay. So basically, as Sir told, Mr. Thapa told that I founded Nilkamal and Associates, and this was like 3 years back. We started the venture uh, after around 15 years of my practice with other various other law firms. And prior to jumping into the IPR field, I did my BSc Honors Chemistry from Kirodimal College, Delhi University. Then I did law from Faculty of Law, Campus Law Center. And I got enrolled trademark copyright designs. And it has been 17 years now that I've been taking care of these things. And during my professional journey as an IPR attorney, I've assisted and I'm currently assisting a number of domestic and international clients. And I've assisted them in conducting prior art searches, draftings, filings of patent, prosecution of patent applications, designs, trademarks, copyright design, like the entire spectrum of IP, as I said. So today I would briefly I will introduce you about the IPR, like why innovate. So basically, what the way we will take up the today's presentation is like first we will briefly discuss. I'll tell you about why intellectual property is important for an innovation. Why do we need to protect innovations? And how do we protect them? What exactly is the IPR in the sense like what all different components of IPR we have, and then we can have a question answer session round, and that's all about it. So I'll share my screen with you people for the presentation.
Sure.
Take a few seconds. So I'm not able to share it, please.
Okay, just give me a moment.
Basically, this
Oh
is
yeah,
the. Can you see?
yeah, I can see it now. Yes.
Okay. So basically, innovation and intellectual property rights. Why protection? Why should we protect innovation? You can see my screen now. Hello, sir.
Oh yes, ma'am. We can see your screen.
Okay. So, innovators are increasingly engaged in developing products and technologies that are commercially viable. And this protection of innovation is important for the economy and for its further growth in areas such as research, further innovations, and employment. So, this is because intellectual property involves the product of human mind and it can be protected. Without protection of ideas, businesses and individuals would not reap the full benefits of their inventions, and of course, they would focus less on research and development. So basically, the idea behind protecting innovations is that to increase the focus towards research and development. So basically, when we protect our invention, we get a monopoly right over it. Uh, I should say that we get an exclusive right over it. And once the inventor or the assignee, he gets an exclusive right over his invention or trademark or any other IP, then of course, he can commercially use it and exclude others from using the same invention or the technology without his permission. So that would enhance people's orientation towards research and development. So that is the basic idea, and it basically gives it is commercially viable as well. Like it gives economic growth also to the inventor and to the assigner. So similarly, in case of artists like copywriting things, logos and other things, so artists would not be fully compensated for their creations if their IP is not protected. So if their innovation, if their art things, their things are not protected, so as a result, cultural vitality would suffer. So that is the main reason behind protecting the innovations. So, how do we protect these innovations? This is through intellectual property rights. We gain a right over our intellectual property. Why we call it intellectual property? Because it is a product of human mind. We create, we think we get something innovative, and we develop something new. We develop something new, and that becomes our property. We get a right over it. Government gives a right over it, exclusive right. And the basic premise behind it is that we get a right by sharing the knowledge publicly. So it enhances the research and development further. So intellectual property rights are exclusive rights over the creations of human mind. A creator can have exclusive right over his creation for a certain period of time. So we will discuss about the durations of IPR in subsequent slides, and because it varies from on the kind of intellectual property right that you gain. And intellectual property right drives economic growth and competitiveness, and it helps generate breakthrough solutions to global challenges, encourage innovation, and reward entrepreneurs. So, essentially, intellectual property rights are recognized and accepted all over the world. It's not just in India or in the US or in UK that the intellectual property rights are recognized. They are recognized all over the world. And the reasons are to encourage creations and originality, to provide incentive to the new creators, to provide due recognition to the creators of the intellectual property. So there's a difference between providing incentive and giving a due recognition. Due recognition, it's said because sometimes like it happens that the inventor, he assigns the application, he sells the application to the company or somebody else, but still his name is still there as an inventor, so he has been given a recognition. And similarly, in case of copyrights in say actors and like performers rights and other things, so they are given a recognition, and it encourages inventors and owners of the intellectual property to make it public so that others can also get the benefit. Once we know that this thing already exists and this is the technology, once we make it public, this is the current technology that is going on, and so we can develop it further. We do not have to reinvent the wheel. So, what has already been invented, we are inventing it again. We are trying to get into the same thing again. So that is not there. So that is the reason why intellectual property, it is encouraged that intellectual property is made public. Now the types of intellectual property rights and governing statutes in India. So we are talking of India only here because the rights are territorial in nature. Territorial meaning by that they are they are with respect to a particular country. So the Patents Act 1970. This is the governing statute in India, the Patents Act 1970. So in US, there's another. They have another act for the patents, for the trademarks, copyright design, everything, and UK has a separate act. So because these are the territorial rights, so a patent that has been granted in India has an effect in India. There is nothing called global patent in the till now. Like it is not that you get a patent in India and your invention is protected all over the world. No, it's not that. You have to file individual applications in different countries wherever your technology is commercially important and wherever you want to get it protected. So trademarks in India, the governing statute is the Trademarks Act 1999. Copyrights is the Copyright Act 1957. Design, the Designs Act 2000, Geographical Indications, Geographical Indication of Goods, Registration and Protection Act 1999, and then Trade Secrets. So trade secret is something we will discuss later on. There's no governing statute in this regard, because this is a secret. This is a different kind of a protection, not a protection, but yes, this is a different right altogether. That basically we have legal remedies to it. There's no particular statute regarding this. And duration for which the creator has exclusive right depends upon the type of intellectual property, as I said earlier. So validity is like patents are valid for 20 years from the date of filing, and there is no extension beyond 20 years. Before 20 years, every year it has to be renewed. And it is renewed for a period of 1, 2, 3, whatever amount of fees you pay. It can be renewed, but there's no extension beyond 20 years. Trademarks are a trademark when it is first registered. It is registered for 10 years from the date of filing, and it is renewable every 10 years successively. So basically, in the slots of 10 years, first you get it registered 10 years from the date of filing. You get the registration is effective, and before the expiry of that 10-year period, within 1 year before that expiry, you can apply for renewal of your trademark. So it will again be valid for next 10 years, and then again for next 10 years. So successively, it is like it can be renewed.
Ma'am, I'm sorry to interrupt the flow.
Yeah, yeah.
Ma'am, can you actually get into a slideshow mode?
Sorry.
Increase, can you get it? Can you get into the slideshow mode? In the sense, like, can you increase the size of your presentation?
Okay, so basically you want the slides to be.
Yeah. So if you see at the bottom, there's notes, comments.
Hmm.
Yeah. So you can go after comments. There are the fourth button. Yeah,
Yeah,
after comments, fourth button. Yeah, after that,
yeah.
fourth one.
Fourth
Yeah,
one.
that's one.
Okay, you want a slideshow.
Yeah, slideshow.
Okay.
Sorry, sorry to actually disturb your flow.
No, 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 that's okay. Okay, right. So, designs, we have talked about trademarks. The validity for a design, initially it is 10 years from filing date, and it is renewable for further 5 years. So, thereafter it is not renewed, it cannot be renewed. So, maximum period of protection for a design registration is 15 years. Geographical indications, it is similar to trademarks, 10 years from the date of filing, renewable every 10 years successively. Trade secrets, unlimited time period until the time you can keep it as a trade secret. And then copyright is usually lifetime of the author until 60 years following the year of death of the author. Broadcast reproduction right is for 25 years, and performance right is for 50 years. So here I would like to tell you about startups, as like IPR and startups, how startups are benefited, what are the opportunities available for startups, what are the basically incentives given to a startup regarding in terms of IPR. So with an objective to promote awareness and adoption of IPRs by startups and facilitate them in protecting and commercializing the IPRs by providing access to high quality intellectual property services and resources, including fast track examination of patent applications and rebate in fees, the Scheme for Startup Intellectual Property Protection SIP is provided to facilitate filing of patents, trademarks, and designs by innovative startups. Various measures being taken in this regard include, so basically there are three um, incentives, sort of incentives, and given to the startups regarding three benefits given to startups regarding intellectual property right protection. So one is the fast tracking of startup patent applications, and they can be fast tracked for examination and disposal, and for the recognized startups. So generally, the patent application process in India takes 3 to 4 years, maybe even more, due to depending upon the workload on the patent office. And with the fast tracking of startup patent applications, a patent may be granted within a year. Then, second main benefit is the on rebate on filing of application. So 80% rebate is provided for filing patents as against the other companies. So generally, the cost of filing a patent application is 8,000 rupees up to 30 pages of specification and 10 claims. But for a startup, the official fee is same as that of an individual. This is 1,600 rupees for up to 10 claims and 30 pages of specification. So I'm saying 30 pages of specification and 10 claims because beyond 30 pages and beyond 10 claims, for every claim and for every page, there is a certain fee that the patent office charges with respect to the specification and claims. So this helps them to cut down the cost in the early years because they are just establishing their business. So this is a very good incentive given to a startup. And then 50% rebate is there for filing of trademark applications. So again, for the company, the official fee is 10,000 rupees. But for a startup, the official fee is 5,000 rupees. And there's another benefit of 500 rupees if we go for online filing. So 4,500 becomes the official fee then in that case. Then there's a panel of facilitators to assist in IP applications. Facilitators are responsible for providing general advisory on different IPRs and information on protecting and promoting IPRs in other countries as well. Central government bears the entire fees of the facilitators for any number of patents, trademark or designs, and startups only bear the cost of the statutory fees payable. So these are the main benefits given to a startup in terms of IPR protection. These are over and above the other benefits like on taxations and other things. So what is essential for, what are the requirements for a company to be a startup? So there are 5 parameters. One is company age, then company type, which all type of companies or organizations, we should say, can be considered as startup, annual turnover, original entity. Original entity meaning entity should not have been formed by splitting up or reconstructing an already existing business. This is because the age of entity, the first clause, this age of entity, period of existence and operation should not be exceeding 10 years from the date of incorporation. And it's not that if it is formed by splitting up or reconstructing an already existing business, then it's not that the age will start from that particular time. It will still start from the it will start from the earlier when the business started. So startup 10 years from the date of incorporation. And company type, private limited company, a registered partnership firm, or a limited liability partnership. Annual turnover should not exceed rupees 100 crores for any of the financial years since its incorporation. And it should work towards development or improvement of a product, process, or service, or have scalable business model with high potential for creation of wealth and employment. So these are the criteria for a company to be recognized as a startup. So now, one by one, we will discuss about the various types of intellectual property rights. So first, we will discuss about trademarks. As you can see over here, There are different kinds of trademarks, like there's an image, there's label, there's just a word mark, and things like that. So Trademark Act 1999, we talked in previous slides that Trademark Act 1999 is the governing statute regarding trademarks in India. So this defines a mark in section 2M as it includes a device, brand, heading, label, ticket, name, signature, word, letter, numeral, shape of goods, packaging, or combination of colors or any combination thereof. So, for example, a label contains information about the product on its container, packaging, or the product itself. So, this is a label. It can be protected as a trademark as a whole. A trademark is a right granted to the owner of the mark by the government as a protection for the investment in a brand. And it can be a unique letter, name, device, word, or a combination of these things. So letters can be a trademark, name, your own name can be a trademark. You can trademark a device, for example, this figure, McDonald's way, I'm loving it with a tagline, I'm loving it, M with a tagline. And so this is a combination of the device and tagline. BMW, BMW is a trademark, and this is the image with which it comes over. So this is a combination of letters and a device. So device is basically the picture element in it. So combination of colors which is used in trade with goods or services, and the basic premise is that it indicates the source of good or services so that it distinguishes the goods or services of the others. So BMW, you know that this particular vehicle, this particular car will come from this particular source. The source is the same in for each BMW car. Nissan has its own Nissan Motor Company has a trademark as Nissan. You know that this particular car, which is labeled as, which has a trademark, has bearing of Nissan as a trademark. This is basically the source is Nissan Motor Company. It comes from that, and then it promises, guarantees you particular quality, particular features, particular quality basically that usually emanates from that source of goods or services. And it distinguishes the goods or services of the other people from the other traders. So these are the functions of a trademark. It identifies the product and origin. It guarantees its particular quality, and it creates an image of the product. So before investing in a brand and before adopting a trademark, it is recommended to conduct availability search. Now, availability search can be in trademark registry database, and it's since like there's one more aspect to trademarks. It is not just registration; it's common law rights as well. If somebody is using that mark already, though it has not got it registered, so even that isn't that can bar accept registration of your trademark. So that may or may not. So these are technicalities, legal obstacles, which we can discuss later in subsequent sessions. So, but the primarily before adopting a trademark, you should conduct a start. Anybody who is trying starting to use the trademark, he should conduct a availability search. So although the trademark searches are not conclusive, because as I said that the mark may not be there the person may not have filed the application for a trademark, but he may already be using it. So by virtue of using the mark, he may have some rights. So that is why we say that trademark searches are not conclusive, but at least they are helpful to ascertain whether there is an identical or similarly mark which exists already in the registry database. So you can outrule a good number of marks that they're not there in the registry database. And you can also take opinion from an expert attorney on the same. Now, there are variety, fanciful marks, arbitrary, suggestive, descriptive, generic. Generic terms are basically these are very difficult to trademark. They are in a way not trademarked. You cannot get a trademark protection for a generic term. And fanciful or arbitrary marks are these are basically the ones which are very easy to get protected, fanciful and arbitrary. And for example, coined words and arbitrary words, like it does not have a meaning related to that the products. Suggestive and descriptive. Descriptive is basically it describes goods and services for which it is to be used. So such marks are not registered. And so this is the level of difficulty of trademark, and this is the level of ease to trademark. So fanciful marks are easiest to get registered, arbitrary, suggestive, descriptive, generic. So businesses should avoid adopting descriptive or generic terms as trademarks. So what are the advantages of getting a trademark registered? A registered proprietor of a trademark is entitled to an action for infringement of the trademark, and a trademark provides the owner with an exclusive right to prevent others from using the mark in an identical way. Identical way means identical mark on identical goods and services. Using a similar mark that creates confusion in the minds of public, which creates a confusion in the sense that people get confused that is it that this particular product, by looking at the mark, they may think that it originates from a particular source, which it does not. So it should not create a confusion in the mind of public, and it prevent others from using the mark in a way to exploit its reputation. So basically, it should not give a negative reputation. If somebody is using others' mark, it should not give a negative reputation, negative thing about that mark, and it should not exploit its reputation in his own favor also. So R symbol, R in circle, it is used to denote a registered trademark, and TM symbol is generally used to denote an applied trademark. Now coming to copyrights. Copyright provides its holder a right to restrict unauthorized copying and production of original expression. Example, music, movie, software, paintings, sculpture. So these are all in term copyrighted matter of copyright protection. These are not these do not fall under trademark or patent. They come under copyright protection, and it protects the expression of ideas, words, and illustrations, and not the idea itself. For example, if I have an idea of clicking the picture of Taj Mahal or any other monument, so this idea cannot be copyrighted. Anybody can click the picture. If there's something happening, some natural phenomena is happening, and different people can take different pictures, photographs of that particular phenomena. But So the idea of clicking the picture, taking a picture of that particular phenomena cannot be copyrighted. But yes, the expression of ideas, the way the picture is, way the picture is clicked, not the way, basically, after the picture is clicked, then it's that picture can be copyrighted. That photograph itself can be copyrighted. So there are various types of copyrights are literary works, dramatic works, artistic works, architectural works, musical, sound recording, and cinematograph work. So literary works includes novels, books, compilations, computer programs. Dramatic works are screenplay, drama. Artistic works are images, paintings, photographs, logo, chart, drawing. Architectural works are buildings. Musical works, music notations, and symphonies. Sound recordings, for example, CDs. So basically, cinematograph work is visual recording and sound recording together, movies and videos. So where visual recording is also an element of a work, so visual recording is accompanied with the sound recording, then it comes under the cinematograph work. Copyright office is located in Delhi, and to copyright something, three elements are required: fixation, originality, and expression. So these are the three elements. As we said that we discussed that idea cannot be copyrighted. So fixation is very important for that. A creative idea must be locked in a permanent state. Example, to protect a song, it must be notated on paper or recorded onto a tape or CD. So this is fixation of the work. Fixation is very important. Then the work should be original. Direct copy of someone's work and mere facts and short phrases cannot be copyrighted. So facts cannot be copyrighted, short phrases cannot be copyrighted. Direct copy of someone's work is not copyrighted because originality is a very important element. And then expression. Expression of an idea can be copyrighted. Ideas itself cannot be copyrighted. Now coming to patents, according to Section 2M of the Patents Act 1970, patent means a patent for any invention granted under this act. A patent is an exclusive right. Exclusive right is basically you are excluding others to, it's a negative right. You are excluding others to use that particular technology or to commercialize that particular technology. So a patent is an exclusive right granted to a person who has invented a new and useful article or an improvement of an existing article. So these are product patents when there's an article or an improvement in an existing article, or it is a new process of making an article, process patents. So there are two types of patents: product patents and process patents. So patent is usually granted to a person who has invented a new product or process. And we will discuss later on that patent is granted to a person who has invented, if not to an inventor, and if the inventor has sold his invention to to a company or to someone else, then it can be granted to that assigner or to that company. So basically, sorry, assignee. It can be granted to the assignee as well, or to the legal representative. Patents means it is a right granted by the government to a patentee to allow or disallow others from taking certain actions. It is a right to the exclusive manufacture, use, and sale of an invention or a patented article. So basically, it is an exclusive right to manufacture, use, and sale. So there are three things: manufacture, use, and sale of an invention or a patented article. and it is granted by the government in consideration of full disclosure of the invention. This is a very important aspect. Why government gives that right to a person, to a patentee, to exclude others from using, manufacturing, or selling the invention. It is because consideration that government wants is that the invention should be fully disclosed to the public. So once the invention is disclosed to the public, so subsequently, after examining and on the, of course, substantive and procedural laws, then government grants the patent. So invention, there are three elements for an invention. Invention means a new product or process involving an inventive step and capable of industrial application. So invention must be new. It should have an inventive step. That is, it is technically advanced, and it is not obvious to a person skilled in the art. And it has some industrial application. That is, it is capable of being used in an industry. Indian Patent Office functions from 4 locations. The head office Calcutta, Delhi, Mumbai, and Chennai. And territorial jurisdiction of a patent office is decided based on the place of residence, domicile, or business of the applicant. In case they are joint applicants, then the place of the first mentioned applicant is considered. And it depends on place from where the invention actually originated. Address for service and inter given by the applicant when the applicant has no place of business or domicile in India. So this third thing is for the foreign applicants. Now, who can file an application for a patent? So a true and first inventor, so the person who has invented that particular technology, the product or the process. So true and first inventor, or assignee of the true and first inventor. Assignee means the person to whom the inventor has sold his invention, and then legal representative of the deceased true and first inventor, or legal representative of deceased assignee of the true and first inventor. Term of a patent is 20 years from the date of filing. Now coming to industrial designs. Design means the features of shape, configuration, pattern or ornament, or composition of lines or color, or combination thereof applied to an article. So basically, design registration is for the aesthetic appeal. It has nothing to do with the technology. So design is for the shape, configuration, pattern, or ornament, or composition of colors. It is not a mechanical or technical feature that is protected in industrial design. It is basically the shape feature. Excuse me for a minute. Sorry. So who can file an application for a patent? We've discussed it. Industrial designs refers to the ornamental or aesthetic aspect of an article. So it is to be judged solely by the eye. No functional or technical feature of the article is to be considered or protected in a design. A design may consist of three-dimensional features such as shape or surface of an article, or two-dimensional features such as patterns, lines, or color. So 2D or 3D, both type of designs may be protected. So prerequisite is that design should be new and original. It should not be disclosed to the public anywhere in India or any other country by way of publication in tangible form or any other way prior to filing date. So in patents and in designs, both the protections, to get the protection, publication before filing the application may be dangerous. And like designs, in designs, it should not at all be disclosed to public before the filing date. And design should be in patents. I say this because in patents there are certain grace periods available in certain countries, but primarily it should not be disclosed anywhere before the filing date. And design should be significantly distinguishable from known designs or combination of known designs. And term of protection of designs we've already discussed. The designs office is located at Kolkata. Who owns the design right? Typically, the creator of the design owns any rights in it, except where the work was commissioned or created during the course of employment. In which case, the rights belong to the employer or party that commissioned the work. So these are basically contract for hire and employment in the inventions done or design work done during the course of employment. Geographical indications indicate that the particular goods originate from a definite geographical territory and assures quality or reputation that are due to its origin. So the manufactured goods should be produced or processed or prepared in that particular territory. So, and it has a special quality due to the geographical environment or reputation or specific manufacturing skills and traditions from that particular geographical territory. So the quality or the reputation is due to its origin. For example, Darjeeling tea, it is grown in that particular area in Darjeeling. So, and it promises, it assures that it would have a certain taste and quality. It has a reputation. So that is how it has been granted a GI tag, Geographical Indication tag. So GI is used to identify agricultural, natural, or manufactured goods. It is on the goods, not on services. And goods are categorized into agricultural products, handicrafts, manufactured goods, and textiles. GIs can be protected over long periods as long as it can be maintained. And in India, it is protected for an initial period of 10 years, which can be renewed after the expiry of the initial period of protection for another 10 years. Some of the examples of GIs in India are Darjeeling tea. So it is in agricultural category. West Bengal, it originates from West Bengal. Idumishmi textiles, handicraft, Arunachal Pradesh. And then Dindigul locks, manufactured in Tamil Nadu. So these are some of the examples. Nagpur orange, we all know, agricultural, India, Maharashtra, and Madhya Pradesh. Alfonso for mango, agricultural, and it's in Maharashtra. Geographical Indication Registry is located in Chennai. Now, coming to trade secrets. Trade secret is any confidential information not generally known or reasonably ascertainable by others, and by which a business can obtain an economic and competitive advantage. So, an important element of trade secret is that the invention should be confidential information. So it is different from all other protections basically because this should not be published. Publication is totally fatal for a trade secret. It has to be a confidential information. It has to be economic. It has to have an economic and competitive advantage, and it is not generally ascertainable by others. Information that has commercial value and has been diligently kept confidential will be considered as trade secret. Owner will be entitled to legal remedies against those who use it without authorization or steal it. These are a few references and which from where we have used in this slide. I have a few questions for you. I'm closing the slides and to check your understanding. Basically, what sir, can we take up the question answers?
Yes, definitely we can go ahead and do that. So I think we have already one person. Okay, I'm handing up the mic to Prashant Goyal. Okay.
Okay, yeah.
Hi,
Yeah,
Prashant.
hello. Hello, I'm audible.
Yes, you are.
Yeah, first of all, thank you for a wonderful session, ma'am, and good evening to all, Saini, Dipuraj, and Sanjeev, and rest all. So I'm Prashant, founder of Adya Innovation, ma'am. I have certain query regarding our brand, which we have already registered with IPR. So I have some 3 to 4 questions to ask. If I precisely start, it's like first. For our first question, we have a brand Adya and brand Shima. Shima we deal in a products and Adya is for the services. So for Adya we have taken trademark in 8 classes. Hello.
Yeah,
Hello.
please go ahead.
Yes.
Yeah, can you hear me?
Yes, yes, we can hear you.
Adya we have taken trademark in 8 classes. Like 4 is for the goods and 4 is for the services. So we got an objection from trade registry in that regard. So we have already filed the notice reply to that. So, ma'am, I just want to seek your advice that what is the percentage you see that we get our like brand accepted and like advertised.
So one is, am I audible?
Yeah, ma'am.
Yes, yes.
Okay. So one is that we need to know the nature of objections that the registry has communicated. The registry has raised with respect to the mark. So whether the application has been filed in one class. Sorry, you said that it is in 4 classes of
Yeah,
goods and services.
yeah.
The separate applications must have been filed, or there are multi-class applications?
There are multi-class application for different classes.
Different classes. Okay.
Yeah.
So, of course, one is if you can help me with the application number. Otherwise, then we can look at the registry
Yeah,
database.
sure. Just to share, like I can give you the number in a chat box so that you can.
What is the basically objection? It is about section 9(1)(a) or section 11. Have they cited some marks, similar marks?
1 second, ma'am. 1 second. I'll share you one. I'm just opening one objection. Okay. So, ma'am, if I share you the number, I guess you will be better person to see like what is the objection. If I'm not wrong, can I share you the application number?
You can share me the application number, and but it'll take me some time to get through all the documents. And since you said that there are 8 applications to it, so it will take time. We can discuss it separately. But
Okay.
the chances of acceptance are basically on one is how many cited, what is the nature of the objections and how they have been replied to it, whether all the objections have been taken care of while filing the reply. And if
Okay.
not, if and I tell you that if just in case the written response is not acceptable to the registry at this stage, then the registry may even appoint a hearing to it. So
Yeah, we have heard this that there are basically maximum 3 or 4 hearing you get to know that whether we will get or not. So
yes.
basically, what I understand, ma'am, it's just a similar name. Okay, objection is only due to the similar or similar type of name, but
Okay.
it's not pronunciation is same, but it's not exactly the same name which we have used. But the advantage with us is like that our company name and the
Hmm.
brand name is exactly the same. Okay, so do you see any chance of preference in this regard? And also we have got the certificate from Startup India, and the since we got an objection from a different class
Hmm.
for our class. So yeah, do you see any probability that what I know you cannot guarantee me. I just based on your experience, I'm just asking this.
So based on my experience, basically, I can comment only after I look into the case.
Okay, ma'am.
Because, yeah, of course, if the goods are different, then the chances are fair enough to get the mark accepted.
Hmm.
But we cannot comment without looking at the matter. In the
Okay,
sense,
ma'am.
this is
And,
a big
and and is this and these objection are auto generated by the trade registry or something like that, or
no,
the
there is
person associated with the company has filed this?
the objections are not auto generated. They are
Okay.
basically examiners who look at your application, they conduct a proper search to it, and
Yeah,
then
yeah.
they raise an objection or not, or they
And
accept that.
those people are like government people, right? That those are not a
Yes, yes.
private service. Okay.
No, 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 not at all. There's a separate registry to it,
Okay.
and there are government people who take care of the applications, who examine the applications.
Okay, ma'am. Can I ask some more question, or someone else should be given a chance?
I mean, yeah, you
Uh,
can contribute to it.
and can I continue?
Yeah.
Yes, yes, please.
Okay, okay. And like, ma'am, we have one brand which only deal in a products, consumer electronic products. So there is
Hmm.
a confusion that whether it is covered in a class 9 or class 11, like for the mobile accessories and consumer electronics.
Mobile accessories are usually covered in class 9.
Okay.
You can refer to NICE classification for this. It is available on registry website.
Mm-hmm.
And class 9 is usually for mobile chargers, mobile accessories, and softwares and electronic items.
Mm-hmm.
Yeah.
And ma'am, one more question. Like out of one application, we got the status of application as accepted and advertised before it was applied. So what will be the next process? Like are we our brand is accepted by the authority, or there is some waiting period more of like 2 to 3 months?
So basically, this means that your mark has been accepted by the authority for those particular goods or services, and then once it is published in a journal, then it is open for 4 months for third party opposition. So
Okay,
any
understood.
third party who feels that who thinks that their mark is similar to your mark, or
Mhm.
have reasons to believe that, then they can file an opposition. So this is
Then
a
again, that objection process will start.
no, that would not be an objection from a registry. That can be an objection from some company or a private organization.
But the process is same for the like reply and like the hearing and all.
The process is not same, I should say, because in the before acceptance, the proceedings are in between the applicant and the registry, and after it is accepted and it is published in the journal, So, and if it is opposed, if at all it is opposed, then the proceedings are between that particular party who has
Mhm.
opposed the opponent and the applicant.
Okay, so basically, what I understood, if I summarize, that there are two cases, two chances of the objection. One from the trade registry first, and if it is accepted, then it is published in a journal, and then the concerned party whoever feel like can oppose the same. So, ma'am,
Yes.
what is the basic time you feel like it takes after acceptance and advertise to get the certificate of the brand like trademark?
So basically, after 4 months of this opposition period expires, and if there is no objection, there is no opposition, I
Mm-hmm.
should say. Then in the fifth month or maybe sixth month, usually these days registry is functioning really fast, and within a month within a month after, like in the fifth month of publication, after publication, the mark gets registered. You get the registration certificate.
Okay, understood. Ma'am, only last question. Sorry to take your so much of time. Since you mentioned that many brand have a slogan attached to it, like McDonald's, I'm loving it.
Hmm.
Similarly, we have a brand Adhya. Its slogan is Generation Ahead. So, if someone can also object the slogan which is inside the logo or trademark.
It depends on whether it is like a usual kind of a someone can object if he's already using that mark as it as a trademark,
Uh-huh.
and if you're but there are other ways to protect it, like you can say that no, it is related to it, my logo is different, my mark as a whole is different.
Okay, okay, okay. Understood, ma'am.
Yeah.
Thank you for your time, ma'am. Thank you for your time. Thanks a lot.
Yeah.
Thank you, Prashant. Uh, okay, we have Sanjeev Kumar who's asking. Sanjeev, do you want to ask yourself, or should I just read it out? The question. And before we go ahead, what I'll suggest everyone in the meeting out here, if you have any questions and doubts that you want to actually discuss with ma'am, try to route it through sign in incubator, okay, rather than directly disturbing ma'am and as such. So it's always easy if sign in can actually help you to connect with the ma'am after discussing with her, okay. So I have also already dropped the email ID out here. You can drop your note. So there is a question from Sanjeev, ma'am. So he's asking, what about bulk trademark? Can I apply for 10 product in bulk and any fee discount on it?
Can you please repeat it again? Can you please
Yes,
repeat?
yes. He's asking, what about bulk trademark? Can I apply for 10 products in a bulk and any fee discount on it?
Okay, so basically, there are 45 classes in which of goods and services and all niche classification, in which the in which one can apply for a trademark. So there's nothing like bulk discount for applying 10 applications or 4 applications. You get this much discount in terms of official fee or like that. But yes, there's a discount in terms of if you're a startup, the official fee is less. We already discussed that. And in one particular class, like for example, clothing, footwear, headgear, this all covers in class 25. So class 25, it is not necessary, it is not required that you file separate application for clothing, separate application for footwear or headgear. You can file as many services, goods, or as many goods as they appear in that particular class, depending upon whether you have intention to use upon that particular goods or services. So registry does not offer a bulk discount. Like if you file 10 applications, then the fees is this or what. It is per application, the fee is fixed.
Okay, I think Sanjeev is thanking you. I think you have answered his question.
Thank you.
Okay. So, is there any other questions from the team? Anyone else wants to raise hand and like ask it directly? Mm, so Prashant, here we have one more question. So Prashant, like, would you like to ask it? Like, raise your hand and I'll give you the mic.
Yeah, hello. Since no one is asking anything, I found this opportunity and like to interact with ma'am as much as I can. So, ma'am, the basically, if I was going through your session, so in trade secret, you have also mentioned that trade secret also cover the unique business idea. So, and the idea or information should also have a commercial value. So, how to determine that the information have a commercial value? Is there any parameter to determine? Because how can you like materialize the information? Because information can be the data itself. Like, I hope I'm clear on the question.
So basically, your question, what I understand is that how do you know that it has a commercial value,
Yeah, exactly, ma'am. Exactly.
and how do you keep it as trade secret?
Yeah, yeah, exactly.
Okay, so for example, this is basically an administrative kind of a question. Reason being because, for example, there is a certain formula. There's a new formula that you have come across for making a particular, say, drink. For example, Coca-Cola. So,
Okay.
Coca-Cola, there's a particular that is the formula is a trade secret. They have not disclosed the formula to anybody,
Okay.
and that is a trade secret.
Mm-hmm.
And we all know that it has a commercial value to it.
Mm-hmm.
So, this is one of the examples. I hope you can
So
understand.
basically, it applies only on a manufacturing industry, if I say precisely.
No, it applies in service industries as well. Like sometimes it is like your customer list is a can be a trade secret. It can be
Yeah.
a trade
Okay.
secret. It has a commercial value and like it commercial advantage it has. And if you are creating effort, you have created diligently. You have saved it. Your then it can be a trade secret. It can be in service industry as well.
Okay. Okay, ma'am. Thank you. Thank you very much on the clarification.
Thank you, Prashant. Okay. So I'll give like 2 more minutes. Ma'am, like, would you like to actually get back to the questions that you were actually discussing before we went to the actual Q&A?
Yeah,
Probably like, yeah.
yeah, certainly, certainly. Just give me 2 minutes. I prepared a few questions, some five, six questions. You can quickly take them up. So basically, I think you can answer in the chat box. What is the duration of IP protection for a granted patent? So the options are you can write A, B, C, D in that particular order. 7 years from the date of filing, 10 years from the date of grant,
Sorry, ma'am.
7
Are you
years.
sharing your screen?
Okay, I'll share the screen and then it will be easier.
Yeah, it will be a little hard for people to follow.
Certainly, certainly. I'll share the screen. Can you see the screen?
Yes.
Okay. So you've got 4 choices.
So yeah.
So can I have a look at the answers? Like,
So I think guys, you can please reply to this in the meanwhile.
okay, just
So we have two answers. One is okay. We might have actually run the poll if it was okay, but anyways, I think like that's totally fine.
so shall I answer the question?
So I think a couple of people are attending, attempting it.
Okay.
Santosh. So two answers. We have two answers so far. Okay.
Duration of IP protection for a granted patent.
Okay. So we have three answers, and we can start. So there are three answers. One is
Okay.
B and two are D.
Okay. So it is
And
D.
D. Okay.
Oh, or did I make it a quick thing? I
No, no,
replied.
that's fine. That's fine.
So
So
it's
there's
10
one
years
more
from the
reply.
date of filing, not from the date of grant. It is 10 years from the date of. I'm so sorry that options are not correct, I think. It is 20 years from the date of filing.
So the answer was
Duration of
none
IP
of that
protection is 20 years from the date of filing. None of the options is correct.
off.
So it is 20 years from the date of filing. So, which of the following is not an element of a trade secret? You can see my screen now.
Yes, we can.
Okay. So it should be a confidential information. It should have a patent right. It must have a commercial value, or it must have competitive advantage.
So we have only one answer so far.
And the answer is
We have two. So the first answer was B, and the second is D. We'll wait for a couple of more minutes. Okay, we have two Ds and one B. There is one C now.
I'll repeat the question. Which of the following is not an element of a trade secret?
Okay, so Siddharth has changed his answer from D to C. And
Okay.
I think we have around 8 of the answers with us.
Okay.
Good
So the
percentage is
correct
saying, yeah, sorry,
correct
please.
answer is B. B. It should have a patent right. This is not an element of a trade secret. Trade secrets elements. There are three elements. Basically, it should the elements are. It should be a confidential information. It must have a commercial value, and it must have a competitive advantage.
So we have two correct answers. One is Prashant and other one is Vidya Kumar.
Okay, that's good.
Okay.
So moving on to the next question. Which of the following is a geographical indication? It's quite easy. BMW, Idumishmi Textiles, IBM, or JVC.
So we have 4 answers so far.
Okay.
Five. And almost everyone is saying B.
B, yeah, correct. Idumishmi Textiles is a geographical indication, and the others are trademarks. BMW, IBM, and JVC. These are trademarks. This is important for startups. Which of the following is true for a startup? A. Annual turnover should not exceed 25 crore rupees. B. Period of existence and operations should not exceed 10 years from the date of incorporation. C. Period of existence and operations should not exceed 8 years from the date of incorporation. D. It does not matter if an entity is formed by splitting up or reconstructing an already existing business. So, which is true for a startup?
So we have 8 entries, and all of them are saying B again.
Okay, that's good. So B is correct answer. Period of existence and operations should not exceed 10 years from the date of incorporation. Which of the following comes under the category of literary work? Novels, musical notations, drawings, symphonies.
So we have 4 answers so far. We have 5. I think, closing it now. So everyone has answered number A, that is novels.
Okay, that's good. Novels, correct answer. 3 more questions to go. Which of the following is not a prerequisite for a copyright? Fixation, publication, originality, or expression?
So we have 6 entries so far.
Okay.
There is a mix. 2 are saying A and 4 are saying B.
So B is the correct answer.
B is the correct
Fixation
answer.
is very important. The work should be fixed. Like we discussed in terms of songs, it must be like in a CD or a cassette. Cassettes are, of course, obsolete now in a CD or something like that. So fixation is very important. Originality, it should be new. It should be expressed, not mere an idea. So publication is not a prerequisite for a copyright. At which of the following places is Copyright Office located? New Delhi, Chennai, Mumbai, or Ahmedabad?
So we have around 8 votes, roughly, or seven
Okay.
votes. All are saying New Delhi.
The answer is
New Delhi.
okay.
Hello.
Hello, yeah.
Yeah. So the answer they're saying is A, New Delhi.
Okay, yeah, yeah. This is the correct answer. So last question is, which of the following does not come under the category of an artistic work for the purposes of copyright registration? Paintings, photographs, logos, movies.
Okay. Uh, Wait for 10 more seconds.
Okay.
So we have seven answers, and out of which four have answered, sorry, five have answered C, and two have answered B.
Okay. So the correct answer is D, movies. Movies comes under cinematograph work because these are video and audio together. So they come under cinematograph work. Paintings, photographs, logos, they come under artistic works.
Okay.
I think we're done with the last question.
Yeah. So guys, like I think, it was a very engaging session so far. Before we go ahead and close the session, I still want. Okay, we have Prashant. I think he wants to ask a question. Like Prashant,
Okay.
Yeah,
can you go?
actually, just want to thank you guys that you guys are very lucky. I just want to say why. We are in the process of listing our product on Amazon, but we are not gone live yet. We'll be doing in 1st July. But since during this session, we got an order to order right now. So
Oh, oh,
you both, like ma'am and signing, both are lucky for us. So thank you being lucky for us. Like, just wanted to
oh,
say this.
Okay, that's
thank you,
great.
Prashant.
Thank you
Yeah.
so much.
Mhm.
Okay, sure. So, does anybody have any questions? Oh, so Sandeep, we have a question. Would you like to raise your hand? Sandeep, hello.
Hello, yes.
So Sandeep, you can ask your question.
Okay.
We are not able to hear you, but okay. Sandeep is having some issue with his laptop. The question what
Okay.
he's asked is can a domain name become a registered trademark?
Uh, Domain names, basically there's a uh, sort of restrain on using trademarks as domain names. And domain name can be registered as a trademark. Yes, it can be.
Okay. Sandeep, I hope you got your answer. Okay. So yeah, if like it's last chance for you guys to ask the question, guys. Feel free. If you have any questions, do raise your hand. Okay then. So Neelkamal ma'am, very very thank you for actually conducting this wonderful session today. Okay. So
Thank you.
we really really loved it, and it was really informative. Okay. So I definitely believe, us all the team members out here, they also felt it really useful. So I would definitely suggest people to get in touch, with sign in and sign in basically route you to the ma'am. Okay. So
Yes,
if you have any questions, yeah, please do write us. I have already dropped the email ID. Okay, but here you go again. If you have any questions that you want to write us, and so thank you everyone, for joining this particular session today. We will have our last session of this particular stretch tomorrow, where we'll be talking about artificial intelligence, blockchain, and machine learning. So anything that you just get prepared for tomorrow. Okay. So, ma'am, thank you very much again. So and have a good day.
thank you. Thank you all. Thank you.
Take care. Bye bye.
Bye.